Thanks for joining, everybody. I'm admitting people from the waiting room as I talk. Michael Kennedy with Berding Weil. I am one of the attorneys at our firm handling the association's matters related to the Los Palos neighborhood. My partner, Teresa Felicia, is here as well.
Good evening.
And we wanted to have this town hall to kind of update you guys where we are. We'll be able to do a little bit of Q&A afterwards. This is being recorded and I believe is going to be posted afterwards so that anybody who couldn't join us tonight can see the recording and get updated as well. As you know, there has been a bit of an issue recently with some of the homes in Los Palos, particularly the Zenda estate, having some pretty big events in there that have caused some concerns in your community. We've been asked to look at whether the use of that property complies with zoning laws and with the easement agreement in place. And in order to have some time to try to discuss this issue with Zenda's owners, we entered into an agreement with them in September where the association would not object to the city issuing temporary use permits for events there for a period of 90 days, I think it was, to expire December 1st. And then that agreement was renewable each 90 days, but either party could cancel it on 6 weeks' notice. After some of the large events held there recently, including one with approximately 550 attendees that they did not notify us ahead of time about, the board elected not to renew that agreement. So that agreement expires on December 1st. And so we've been in communication with the city's attorney about how we will not be in a position to approve or withhold our objections to the issuance of temporary use permits for future events after December 1st. Now, the association is not in a position, and we're not in a position to tell the city how to interpret their own zoning laws. It's not up to us to decide whether or not to issue temporary use permits. That's up to the city. And we've been careful not to step into the city's role. I think there's potential liability for the association if we overstep our bounds. However, we can certainly communicate to them about whether or not we object to the issuance of a temporary use permit, which we will be doing for events after December 1st. The owner of the Zenda estate, through his attorney, has made numerous threats to file lawsuits against the association and individual board members if we do not approve these temporary use permits going forward. Frankly, that doesn't concern me very much. My partner Teresa and I both handle litigation involving real estate almost exclusively, and I've been doing real estate related, HOA related, construction related litigation for over 25 years. So that's not a very scary threat when they say that. I think that inevitably it's probably going to take a judge's intervention to interpret and potentially modify the easement agreement with the Los Palos homeowners, because I think there are some gray areas in there and some vaguenesses that allow them to overburden the easement that they have. I don't think we're likely to be able to prevent them from traveling through Polo Club to get to their properties, but we can certainly have a say about how much traffic, how much wear and tear, and how much disturbance they create for you, the residents in Polo Club. Sorry, I'm adding more people here as we go. So, we've looked very carefully at the easement agreement, at the city of Indio zoning regulations, the type of zoning regulations that apply to those homes in Los Palos. There's a 2016 settlement agreement between the Los Palos owners and the association. And it's our interpretation that they should not be able to be having these humongous events. So it's probably time to just have it out and get to a place where a judge makes the call and leads us into coming to an agreement that's more workable for everybody. That's probably going to involve the city, because I think the city's issuance of these TUPs has violated their own zoning ordinances. And so I expect that's what we're going to be heading into next. For a number of reasons, if Zenda initiates the claim against the association, I happen to think just tactically that's better for us than us starting a lawsuit against them. The easement agreement provides for resolution not by litigation with a jury trial, but by a judicial reference proceeding. Judicial reference is kind of halfway between a traditional litigation and binding arbitration. It's appealable. It is entered as a judgment, but it is a private proceeding without a jury and usually heard by a retired judge. Whether the city would participate in that proceeding is another question. We've been in talks with the city's attorney about some of the procedures that will govern this claim going forward, and we expect it to all get started probably pretty soon, because as I say, we're not going to be approving the issuance of temporary use permits after December 1st. That's kind of the overview of where we are and how we got here. I'm happy to take questions or address specific concerns you may have concerning the Los Palos and Zenda issues. I don't know the easiest way to do that with 119 of you on there. Maybe if people want to post questions in the chat, and then I can go ahead and answer them. Looks like someone's got their hand raised, Juan and Agnes. Do you want to type your question into the chat? Oh, the question is, can I say more about the easement? What I think the gray areas are. The easement agreement is the document that allows the Los Palos owners and their guests to drive through your association. It governs, use of the gates and that sort of thing. Without that, they couldn't drive through your association, but that's sort of an island in the middle of the association, hemmed in by you guys. The gray areas, I think, it refers to the Indio zoning regulations, I think, but I think it's subject to a couple different interpretations. In one place, it says that the use of those properties can be for residential and accessory use only, but there are other provisions that talk about commercial uses. And it talks about how they can be compelled to contribute to your reserves if they use more than their allotted use of the streets and gates for commercial uses. So I think there's some inconsistencies in between whether it's residential only, whether some commercial use is permissible, and what the association's remedies are if there is commercial use. Let's see. Let me figure out how to. Why was the easement not disclosed to new homeowners? I don't know. It should have been. It should have been recorded and in the packet you got when you purchased. Why was the letter approving the TUP sent in the first place? The idea was to hold off initiating litigation. They had some events and they were going to file a lawsuit, within a few days when we were negotiating this in September. We got involved to handle this matter. And the idea was to buy a little time and see if we could have a workable arrangement short of litigation. That's why the first letter was sent. There's a question about the validity of the 2016 easement. I think it's valid. It's recorded. I just think it's vague and needs to be reworked a little bit. Exposure against the city. I don't think you're exposed. Well, there's a question about what's the association's exposure against the city of Indio. It's more that the association doesn't have the obligation to enforce city zoning regulations. Cities enforce their own zoning regulations. If you did it incorrectly, and if somebody else said, well, that isn't your place, that's the city's place, you get sued by some other owner for, an interpretation that they disagree with. So I think it's better to stay in our lane and protect your own interests and not interpret the zoning regulations other than to object when they do something that violates the zoning regulations that affects your own use of your property. Viable options for an alternative entry to Los Palos. Not that I'm familiar with. I mean, looking at the maps, and I've been to your property a couple of times. I'm not aware of any other way in other than, taking away part of the golf course. They probably should have granted or created a street through there when they first developed everything. But short of that entire block is taken up by Polo Club and the golf course and Los Palos in the middle. So I don't know of another viable option for entry. Insurance or liability to the community for guests of Zenda, for example, getting hurt climbing over walls. It's a concern if you allowed it and didn't object and knew people were climbing over walls or doing things that might get themselves injured and did nothing about it. That's definitely potential liability. If you're objecting, preventing, and that sort of thing, and it happens anyway, why somebody who got hurt could still file a lawsuit, but you'd have a lot stronger argument to say they assumed the risk and you weren't allowing it, but they managed to hurt themselves anyway. Can they still hold large events after December 1? Well, that's going to be the battle. If we don't approve of temporary use permits, we'll see what they do and we'll see what the city does. But I think that brings us all to a head so that we start the judicial reference matter that we need to have. There's a question about what's Shay's liability or potential involvement in all this. I don't know. I think that's a separate issue. I think the main focus is to prevent future disruptions to the use and enjoyment of your property. This is creating a nuisance to you guys, and I think looking ahead and preventing future events that impact the community is the main focus out of the gate. As residents, what would I like you to do right now? Good question, and I appreciate the proactiveness. I don't think much. If your home is specially impacted, if you're right next to the Zenda property or one of the Los Palos properties, or you see someone behaving inappropriate, climbing over a wall, or guests in Los Palos running through your streets, report it to management. So we're tracking the information. And I think that's as much participation at this point as we would ask. What's the zoning in Los Palos? Those homes are designated DET1. If you want to look up, the city zoning regulations are easy to look up. They're on their own website. And the Zenda, and I confirmed with the city attorney's office, the Zenda property is zoned DET1. There's a question about would you still these problems if they didn't have access to the property? Potentially. It would still be a nuisance, but we wouldn't have the easement agreement. It's kind of two issues rolled into one to you guys. Are they properly using the easement? Are they overtaxing the easement? And is it creating a nuisance to you guys? So you still have part of the problem, but not all the problem. Let's see. Is the easement by necessity or the earlier grant of a license? It's by necessity. It's because Los Palos is essentially an island surrounded by a polo club and by the golf course next door. Let's see. Is Zenda responsible for maintenance? Sort of. There's a provision. That's one of the gray areas, I think, that they do have to contribute to reserves for the extra wear and tear on the streets and gates and so forth from their guests coming in and out. But even if it's commercial use, they're just treated as one more home. So if there's 1,000 homes now, there's 1,001. And I think that doesn't account for the extra wear and tear they're putting on their streets. If you guys are driving in and out each day, that's one or two cars using the streets because of your home. If they've got 40 guests every day, that's a lot more wear and tear per unit. So I think then counting as one unit that's equal to yours is not really a fair allocation for their contribution to reserves. That's one of the issues we'll have to work out in modifying this easement agreement. What's the actual cause of action by Zenda against the HOA? Well, I think that what they've threatened is breach of the easement agreement, breach of contract, and tortious interference with their contractual relationships. What's our cause of action against them? Overburdening the easement and breach of the easement agreement itself. So trying to see if there are any additional questions in here. Let's see. Your options, I mean, the association's options, I think, are either, get to a revision of the easement agreement and change its terms in a way that work for the association. I think that preventing access at all is probably unlikely. Those are big multi-million-dollar homes, and I don't think any judge is going to say, they're worthless and they just can't get to them. I think we could probably prevent some commercial use of them and put pretty strict limits on how they use those properties. And I think that's the goal of the case we're going to have with them. Let's see. Some of these questions are kind of overlapping with what I've already discussed. I mean, there are questions about, what's our more specific plan of attack. I mean, first of all, there are 125 people on here. I'm pretty careful about how much we lay out exactly what our strategy is to a room full of 125 people. I think that the broad overview is I expect Zenda to follow through on their threat to file a lawsuit. And at that point, I think we'd bring in all of the other Los Palos owners into the lawsuit because it has to be binding on all Los Palos owners. I think we'd probably bring in the city. And then I think that we would conduct some discovery and set up a motion for summary judgment and try to get judgment in our favor that way, that they are violating the Zenda owners and the city have violated their own zoning ordinances and violated the easement agreement by allowing so much commercial use of these properties when that's prohibited by the easement agreement itself. And that's created a nuisance for you guys. That's the overview of where I think the case would go and what the strategy would be. Let's see. What's the cost of the litigation? It's hard to say because it depends on how much of a battle they want. One of our tasks is to prepare an estimated budget for the board and provide it to the board. It's going to cost several $100,000 by the time it's over. This is, big litigation with motions and discovery. Judicial reference is a private proceeding that has to be paid for, and this will go on for a while. The good news is that the easement agreement provides for a prevailing party to recover their attorney's fees and their costs against the losing party. In practical reality, these cases almost always settle, but if it goes the distance, there is the mechanism to recover attorney's fees from the other party. But it's going to take a while and cost some bucks. That's why we tried to get to some sort of negotiated agreement and discuss other options where the off ramps were short of litigation before we got here. We do litigation all day, every day, but we always try to find the off ramp and spare you guys all that if there's a way to negotiate that, and there just isn't. Zenda intends to keep having these large events, and this is an issue that's going to face you guys into the future. So we've got to have it out. We've got to work this stuff out with them. And I think the city, frankly, is a little unsophisticated about how this is going to happen. There's been a lot of growth in that area. I think with the festivals at the venue across the street, and the growth of Airbnbs and people coming to your end of the Coachella Valley for these big events, if have the city a little bit back on their heels, and I think that they're catching up on how to deal with this stuff. But it's got to be worked out. A couple more questions about whether the easement would have been listed in your preliminary title report. I would expect it to. If it wasn't, I don't know what to tell you. That's all in individual disclosures, and that's not something that we're handling. Somebody asked, why are the TUPs approved the day of the event? That's a good question. They're supposed to be approved. They're supposed to be applied for, 30 days ahead of time. They're not supposed to have an event more than every 30 days. And those are some of the things that the city has violated. Why are they not approved until the day of or a couple days before? I don't know. I mean, I don't expect, there's anything. I don't know. I think it's the city trying to figure out what to do. I don't know that it's nefarious, but they've certainly violated their own zoning standards. Do we know if the other owners feel that Zenda is creating a nuisance? I don't know. I think I want to engage them and try to get them, talking to us and part of a negotiated resolution of this. I think they all have to be parties because they're all parties to the easement agreement. And if we're going to modify the easement agreement, it has to be applicable to all of the Los Palos homes. We can't have it just with Zenda or just with half of them. And that's why they all have to be involved in this. Let's see, check the zoning regs. Can't find, yeah, it is DET 1. See if I can find. I don't remember what section it is in the zoning regulations, but it is in there. Can we, with regard to strategy, can we charge them to use our easement? Yes, that's the idea. It's going to be a contribution to the reserves, I think. Administrative remedies of going after the city. Well, it's interesting. There's something called the Tort Claims Act where you've got to present a claim to the city before you can sue them. But I expect Zenda to start this by suing us. That's one of the things I'm talking to the city about. As part of putting pressure on the city council. Yeah, I mean, you guys are free to show up at city council meetings. That's not our focus, but if you guys, you can show up at city council meetings and talk to them and talk to the planning commission. What they may do is change their own zoning regulations, though, and kind of head us off. So that's separate from what we're doing, but I'm not saying don't do it. Let's see. Can individual homeowners affected by Zenda go after the city in their personal capacity? Yeah, I think that's possible. I mean, the law of nuisance is if it's affecting your use and enjoyment of your home, then you have a claim against whoever's affecting your use and enjoyment. If a bunch of you are being affected, the use and enjoyment of your home is being affected, then the association can step in and assert the claim on your behalf. So think of most of the law applies to like a condominium building. If your neighbor's playing loud music and it's bothering you, but nobody else can hear it, that's a private nuisance, and you can bring a nuisance claim against your neighbor for interfering with your use and enjoyment. If somebody's sitting by the pool smoking cigars and it's blowing into every unit, that's more broad-based, affecting everybody's use and enjoyment. And that's a distinction that's recognized under HOA law. Zenda is a corporation. It's an LLC. I think it's Zenda Estates LLC. Let's see. We have no privity contract with respect to the TUP and the Zenda owners. Yes, you do. That's what the easement agreement is. If the original easement is in the current location, I don't really understand that. The easement was entered into and I think recorded in 2016 following an earlier settlement agreement. And I don't think it's been modified since then. What does several questions about what does DET mean? It means it's residential. The definition has to do with the size of the lot. There's DET 1, 2, and 3. And DE stands for desert estate, I believe. And there are different permissible accessory uses depending on the different type of property. So, for example, equestrian use is permitted, but animal husbandry, farming is not. Backyard breeding is not. Outdoor entertainment is not. Live entertainment is not. And that's the violations we have here, because those commercial uses, somebody might think are outdoor entertainment, live entertainment, and so forth. And those are not permissible with that type of zoning. Let's see. What's the best way to cause enforcement of the terms? I think, if there's an event going on, I think there's a wedding set for Zenda this weekend. And if they're violating the terms of the temporary use permit with, amplified noise, and the noise is going on, later than they're supposed to, call the police. It's just like the same thing. If there was a question earlier about people, climbing over fences and stuff like that, and what can we do? Call the police. Don't be shy. I've had lots of other clients, particularly in urban areas, LA and San Francisco, where the police will say, we may not come for that one call, but the more you call, the more enforcement you get, the more you're on our radar. So if you think there's an issue, call the police by all means. Somebody had a question, what is Shea doing now to help resolve the issue? Shea isn't doing anything with regard to the Los Palos issue. We've been dealing just with Zenda and the city so far. So that's what's been involved there. I mean, again, we can go back and look at Shea in the past, and should they have signed something that they maybe they shouldn't have signed this or bound the association to that. And we can certainly look at that with regard to Shea, but looking forward and preventing further disruptive events that violate the local zoning ordinances and interfere with your use and enjoyment is the first focus on this case. Let's see. What's the remedy for use exceeding the zoning? I think getting the court to declare that these types of events are impermissible because of the zoning and because of the violation of the easement agreement. The city can change their ordinances if they want to, but I think the fact that the Zenda estate is violating not just the zoning ordinances, but the terms of the earlier easement agreement is what gives the association standing. The law views a document like that like a contract. So if they're breaching the contract and the association is a party to that contract, that's where your standing comes from. So, let's see. I mean, the questions are kind of slowing down. I don't know if I should unmute, people to discuss it without having just sort of a free for all. Let's see. If we prevail in any lawsuit, won't Los Palos sue us? No, I mean, the lawsuit would be with the Los Palos homeowners. So if there's a lawsuit or more accurately, a judicial reference proceeding that's resolved, that should be the end of that case. So, I think, let's see. If you wanna speak one at a time, why don't you go ahead and raise your hands, and I'll unmute one at a time if I can figure out how to do that. Mr. Zizian. I think you can unmute.
Hi, Michael. How are you?
I'm doing well. How are you?
Good, thank you. As you're aware, I've spent probably the better part of the year looking at all angles on this issue.
Mm-hmm.
My concern is not necessarily today, because a lot of our residents here don't even relate to why we're having this issue or why we're spending money on it. The problem I see right now is Zenda's almost created its own problem. But the Zenda estate itself, I think there's many grounds for saying it does not qualify as a single family resident estate because there's no family. There's never been one. It's a constant series of commercial events for commercial purposes only. And I think it's disqualified itself. And I think we could go to the city and sell them, prove it to us, other than they haven't hung a hotel sign on there that says that they're not a business. And in fact, I sent you a report over the weekend that shows that they are listed in the hotel directory for the Coachella Valley as a hotel. So I think that's an administrative remedy, and I like administrative remedies because they're free. I can go before the city council. I already met with the council. I've met with the city manager. I've met with city attorneys, and those people seem to want to help us, but they seem to be lacking initiative or direction. So let's look at the long range issues, what I'm concerned about. There's 9 lots there. We would hope that they would all be nice mansions built like Zenda and lived in by rich people that wouldn't cause a lot of problems for us. But residents there are moving now because they can't stand the music and the events of their own neighbors are putting on. So that's going to leave potentially 9 lots there for huge estates. I've talked to Miles before, and he's concerned about the new ones being built. They're bigger than his. Now, that's competition for him. The one that's probably the worst is the first one when you go through the gate. That's a cheaper rental. So if you have more party homes being built there, you're going to have competition, and the competition is going to drive the prices down. You saw the Wall Street Journal article I sent you about the problem they're having getting big dollars for those. Miles have gotten lucky lately, but ultimately competition is going to force the prices down because they have to cover the bills and their $80,000 a year taxes. So they lower the prices. That's going to bring a different class of people in. And the different class of people are going to give us the same result we had with the Diplo event, where we had people running all over our neighbors and racing Ferraris down the street, and God knows what else was going on. Now they have to come through our main gate with all that traffic and commercial traffic. And I think that once they can't get legitimate owners, or they're going to go across the street to the Madison Club if they want to build that type of an estate. Here they're going to be building where we've created a party zone. That's the only thing that can happen there, or nothing will happen. Well, if nothing else happens and people can't sell their lots in Zenda, and the city goes ahead and approves 4,000 people events on the vacant land, it's not even relating to the homes. They're conducting events on the open land there. And that's unconscionable. So anybody could think a city could sign off on a permit for 4,000 people. So I think we have to put as much pressure as we can to tell the city, or tell Mr. Miles Warner, tell us why you're a single family estate. There's nothing single, there's nothing family about it. And other than the fact that it's a structure that happens to be lucky to be in that zone, they don't qualify to be in that zone for the purpose they're using it.
Yeah, I mean, I appreciate your comments. I think we need somebody has to be the decider because we can talk back and forth between, Zenda's owners, attorneys, and go around and around and around. And I've talked to his attorney a lot, and I've talked to the city attorney a lot. But somebody's got to be the decider. And his attorney has threatened to file a lawsuit in just about every letter he sent me
Sure.
and the association's previous counsel. And so, at this point, let's get it on. And have the judge be the decider, and somebody's got to call balls and strikes. We can't just, talk in circles and never be there while they develop additional properties. I mean, there is more of this coming to this area, and so the sooner we head this off, the better, I think. So let me get to some of these other questions. Let me view who else has their hands up. Let's see. Anita Crandall's iPad has your hand up. And I think I can unmute you. Sorry, I got to figure out how to do this. Ms. Crandall, can you unmute? No? Let's see. I'm trying. Well, let's see. Let's go to Kenmy has a hand up.
Hello, Michael. Thank you for moving over to me. I would just like to offer that I'm not sure why we're not going to reserve and retain the right to have Shea participate in solving this in some way. They're the ones that created the problem in the manner in which they put this thing together. And I'm sure you've done this, if you look back at the original plan for that Zenda area, I think it was supposed to be 24 plus homes, if not more. Mm-hmm. Somebody bought them all up and decided to rearrange the property lines and build these with clear intent, because they were never going to be sold as single family homes that are 8,000-10,000 square feet.
Right.
So it seems that there is more culpability in a broader way that should help relieve some of the pressure off of the HOA. And is that we don't throw out, the original originators of this problem. And there is a way to put a road in for them and get them out of our community. It's going to cost somebody some big money to do it, but it can be done.
Yeah, I mean, I'm not saying we're not going to go after Shea. I'm saying the primary focus, if you go after Shea for things happened in the past, you're seeking damages, right? You're trying to get money out of them. And I think job number one is prevent events in the future and prevent, additional events and stop Zenda, stop, these other lots from being developed into these big party houses and not have the headache grow. So, I'm not saying not go after Shea, but I think job one is to, stop future events and disruptions.
I appreciate what you said. I think job 1A, though, is having the people that created the problem help us, because they have culpability here without question.
Yeah, I'm not disagreeing.
Thank you.
Of course. Thank you. Now.
So this is Anita, and I'm off mute at this point. And so my question is kind of a piggyback to his question. Okay. You stated earlier on that they're landlocked. I don't believe they are always landlocked. So where was the original easement for ingress and egress? And did Shea move that when they built Trilogy around Los Palos?
Not that I'm aware of. I mean, I've got the current document, the current easement agreement that I'm looking at. And so was it originally in a different place? That's not something we've looked at. I mean, and if we're looking at where could we put different access in for Los Palos that didn't need an easement through polo club anymore. As I understand it, it's either through polo club or take away part of the golf course and put a road through there. I mean, we're certainly going to be open to whatever solution, and one that doesn't involve polo club at all, it would be, most desirable. So let's see who else.
He is saying Shay took out the original road.
Let's see. Who's next on here? On the raised hands, I saw April Sanders. Could you go ahead and unmute, please?
Hi.
Hi.
My name's April Sanders. I live right behind the Los Palos house that's being built. I've been working on this for 3 years. I'm going to tell you there is no other easement or way into that subdivision. I've done extensive work. I've walked the property. I've gone to the golf course. There used to be a horse trail that led from the Fetterman's date farm, and there's only 2 residents that live in there. Cheryl and her husband, they live next to the Zenda estate and the Fetterman date farm, which is up for sale right now. There was a horse easement. Lupe Ramos, our mayor, has said multiple times there's another easement into there. It has been built over by Barcelona Homes and by the homes that are on Monte Vista Court, which there's also 2 other party homes there. So there is no other easement in. The golf course is a private, very exclusive golf course. They are not going to sell part of the land to the people at Zenda, nor could they probably afford to buy it because it's very expensive. So make that clear. There is no other easement into that property. The second thing is I've been in constant contact with Preston Holder, the president of Shea. He claims he's working with you on this easement, that his attorney is working with you, because I threatened to sue them because this was not disclosed to me when I bought my home. And I was going to sue them, but the statute of limitations was over. So I'm kind of curious why Preston Holder is telling me that from Shea that they're working with the HOA attorney when indeed they're not.
I don't know. I haven't heard from them.
Well, I will email him and get back to you. Maybe someone could send me your email address or I'll send it to Louise. Thank you for letting me talk.
Of course. Thank you. Let's see. I see Mr. Jay Dougherty. Could you go ahead and unmute, please?
I actually think Joe was ahead of me there. If you don't,
okay.
Yeah.
Okay.
Unless you'd like to defer to me for a moment, Joe. Thank you.
Let's go Joe first. Thank you. Hey, Joe. Oh, you're still muted. There you go.
Are you talking to me?
Yes.
Yeah, I asked the question, Michael. You know, I'm familiar that you're also handling our transition issue with Shea. I've been involved in transition lawsuits before, and with your same firm, as you well know. We didn't have this kind of a problem, but how is this any different with regard to things that remain or are outstanding or have not been accomplished or not done? Any different than, say, our landscaping problems or street problems with regard to transition? Why wouldn't we be eligible to make a claim that our legal expenses and the costs associated with resolving this matter are part of the leftover cost associated with Shea transitioning the property into the HOA completely?
Well, Shea's involved, in both, but it's a different body of law. So the transition stuff is, as you know, Joe, from the other matter we worked together on, is SB 800, the California's Right to Repair Act. that governs construction defects. And so if there are issues with defective construction, then Shea can be compelled to either come back and repair them or fund repairs, and you don't get attorney's fees in an SB 800 case. So this isn't really in the civil code. It's civil code section 896. If anybody's interested and wants to Google it, sets out what all the standards for construction are. And if you violate one of those standards, you have to pay for the repairs or repair it yourself if you're the builder. But you don't get attorney's fees for this. So this is totally different. And this isn't one of the SB 800 standards. And we want to recover attorney's fees. You get an attorney's fees provision in the easement agreement. And I wouldn't want to muddy the waters and give them an argument that they don't have to pay attorney's fees because it's really an SB 800 claim. So I think they need to be very, very separate.
Well, the last thing you said is probably the most germane to this matter, because I mean, we're already establishing quite a bit of cost associated with this, as we all know, or at least the board yourself know. And I don't think we're anywhere near the end. We're just at the very beginning of this matter. So I anticipate in order to finally resolve it, we're going to have more expenditures in the legal category of our budget than we've ever experienced. And frankly, I'm happy you're on the case. I know you, and I know that what your firm is capable of doing, and they do excellent work. But I do believe that in terms of our overall responsibility, there are things that we're going to have to deal with differently, because we're going to have some extraordinary costs associated with resolving this matter. And I would argue as well that the costs are not just something that we're bearing because of people like April Sanders and others, Dick Haney's on here, that are adjacent to this property. Because as all of us well know, and many of us saw, and some of them recorded the video on, Dick's got an extensive video showing multiple trips with very heavy buses going across Polo Drive all the way from the Avenue 52 gate down to the Los Palos gate. And those things in time are going to significantly affect the quality of the streets, which is going to come back to all of us. In addition, I think there's some people that have noted folks, possibly seen jumping over walls and this kind of thing, which affects the tranquility and the security of everybody, regardless of where you are on the property. So this cost may appear like it's associated only with the people that are adjacent, but frankly, and in my own experience, and I think probably yours as well, it's going to impact all of us. So yeah. I appreciate what you're doing, but I do think that this is probably going to be not resolved immediately. It's going to take a while, and ultimately I can see us and joining the city in some kind of an action for violation of their own codes.
Yeah, I agree with you, Joe. Thanks for the kind words. It's not just about the noise for the people that live right next to the Zenda estate. It's we got to nip this in the bud, because as others have mentioned, they're building more of these, and you're going to have big party houses and buses and trucks bringing in the tents and the porta potties for 500 person events, forever. We got to head this off and nip in the bud. So it's going to cost a couple bucks, but we're going to be budget minded. I know you guys aren't budgeted for big knockdown, drag out litigation in your regular annual budget. And, we're going to try to be sensitive to that and not go nuts. And it's going to be spread out over time. But I think it's something the association has to do to kind of nip this in the bud and get this issue under control before it gets a lot worse.
Do we have the option of allowing other properties in the Indio area to join with us in any action against the city of Indio? Because this is going to impact, if they're allowed to get away with this, it's going to impact all the properties within Indio that are going to see their standards and their zoning codes violated by virtue of the city's actions.
Yeah. Maybe, if it comes up, I would talk to them and really need to think through the pros and cons, because it's focused on not just Indio, but the Los Palos homeowners, and Shea may have a role, and that's some factors that are unique to you guys. And so, I'm not saying no, but I'd really need to talk to them and think it through because, you're my client. I wouldn't want to dilute your claims or do anything that's going to be a big distraction or delay for your claim.
Very well. Thank you very much for your
Thanks,
time.
Joe. Okay, now, Mr. Dougherty, would you please go ahead and unmute? I hope I'm pronouncing your name right. I know someone else with the same spelling, and that's how he pronounced it.
Yeah, that's how I pronounce it, Dougherty. Thank you. I'll make it brief. First of all, I agree with Pete Dine that Richard's idea of trying to pressure the city to enforce its own zoning rules could possibly be inexpensive and fruitful. They haven't done it, so I don't know. Maybe they have some other economic interest in allowing these events that would interfere with that. I also agree with Janet Weinstein that it's really two problems we're dealing with here. One of which Joe very correctly pointed out impacts the whole community, which is the impact on the roads. And boy, those buses were really big. I saw them going in. The other is the nuisance and the noise, which bothers those of us that are closer to that part of the community, but not necessarily everybody. And I will say, I'm looking at a Google Maps satellite view, and it looks to me like there is a largely vacant lot, kitty corner to the Zenda estate, just west of our community, bordering on Avenue 50. And I'm wondering, even though April said that there's no possible other access, as to the access problem, they've probably built some homes on there since this satellite picture was taken, but there's a largely vacant lot just west of our community, again, kitty corner to Zenda, and north of the golf course. I wonder if that might be a potential solution on the access part of it. I don't know who owns that property and what's going on there, but it looks completely empty on my Google Maps satellite view. As to the noise, I think that, even though that affects a smaller number of the community, it is unbelievable. And I'm a musician. I don't mind noise. I moved to a community knowing Coachella would be across the street. We get some noisy DJs over there at Coachella. But some of these parties are just nuts. And, some of us call the police sometimes. I've only called them once. It was just beyond. It was coming. If it doesn't come into my home, then I'll tolerate it. If it comes into my home, it's just too much. But I think that they're distinct problems and probably distinct legal approaches and legal issues. And I'm sure, Michael, you're aware of that and thought of that. I'm a lawyer too, by the way, although I'm not a real estate lawyer. So I think that it's important to keep the two issues distinct. And again, that's why I asked the question about nuisance and what cause of action there'd be to enforce the violation or exceeding the zoning, what's permitted under the zoning code, whether we'd have standing to bring that kind of a lawsuit. So I just wanted to clarify for everybody that they're two distinct, related but distinct issues. So that's what I mainly wanted to say. Thank you.
Thank you. Let's see. I don't see any other hands raised. Let me look at the chat again. Let's see. If the easement's renegotiated, what would change? Well, I think that the idea is to clarify that residential use is permitted and commercial use is not. If we wanted to allow some limited commercial use, weddings of 40 or 50 people may not be a problem, but you don't want a 500 person blowout with DJs and stuff going until 2 a.m. And so what's permitted, like I say, I think is pretty clear, but it does talk about commercial use in a couple other places. So there's some conflicts internally in that easement agreement that create ambiguity. And I think that their contribution to reserves needs to be better. to say that, well, it'll be treated just as one more unit if we have a commercial use. So, my example earlier was if there's 1,000 homes and they're number 1,001 and contribute 1,001 of the cost of maintaining the streets, well, they cause 20% of the damage. Well, that's not really fair. And so those are the kinds of things that I think would need to be changed in the easement agreement and prevent these huge blowout parties with partygoers jumping the fences and DJs and huge buses and all that kind of stuff. April Sanders, have you raised your hand again? Go ahead and unmute if you want to.
I just want to point out that for everyone on this call that wants to know about the situation and the zoning and what's going on the TPC, Trilogy Polo Club Facebook page, there is a great presentation that was created by Richard Zizian that was presented to the City of Indio. It's called City Presentation V2 that explains everything about the situation, what the zoning is, why it's being violated, and it's a great read. It's in the documents on the right-hand side of the page. And thank you for letting me talk.
Of course, yeah, no, and if I didn't say before, thanks to Mr. Zizian, I've seen it, and it is a good analysis. We have our own internal research we've performed with, citations to all the chapter and verse we'll use in our briefing, and there's a lot of overlap between our analysis and Mr. Zizian's. It's a good sort of summary of what the issues are. Let's see. Are there any other questions? Have I answered everybody? I've heard a lot of platitudes. I'd like to know just what you're going to do to protect my peaceful application of my property. Well, try to prevent these great big parties from happening on a regular basis is job one, and then create a structure where they're allowed to have what we want to allow them to have, but not these, humongous 600 unit or 600 person blowout parties where they have buses and trucks and stuff driving through your community. And prevent other homes that have the same type of events from springing up in there. I think and have some control over what goes on in there. I mean, we negotiated this temporary agreement with them in September, and I remember Wiles Warner telling us, excuse me, a little bit of a cold, that the events coming up were his wife's 40th birthday party and 2 weddings with like 40 or 50 people. One of them is the one this weekend. And then come to find out a couple of weeks ago that they had a 550 person event that was going to be a awards event for the top salespeople of a large national corporation. And that's what all the buses and porta potties and tents and all that stuff were all shipped in for. And that had been booked months before, and he didn't tell us about that ahead of time when we were negotiating this temporary agreement. And that was a huge event. I'm sure you guys saw it and heard it. That we learned of the day before. I think it was on October 9th. So preventing those kinds of surprises and not telling you about these types of huge events is at the most basic level the goal. So let's see, if the agreement with Los Palos ends in December and the city issues a permit in January, what happens? Well, we could sue them. Again, tactically, Zenda has threatened to sue us first. I think that's advantageous for a number of reasons. Some of which are my sneaky tactics. But I think it's better if they start it. But I don't think the city is going to do that because the city was very hesitant to issue this TUPs without the approval of the association. And they know that we have now withdrawn our approval. I've talked to the city attorney about that. Do the TUPs include an exemption from the city's noise and nuisance ordinance? No, they do not. that noise and nuisance ordinance still applies. And in fact, I think in the body of the TUP, it reminds the people of that. Sorry, I got more people in the waiting room. Make sure everybody's in. Can gate access be enforced so any entry has to be added to the list? Yeah, the Los Palos homeowners are supposed to use the Jackson Gate, and codes unique to their event can be issued to them so that they can't just have unlimited access. Bad actor Miles Warner. No comment. We'll be dealing with Mr. Warner some more in the future. Is any part of the Zenda property zone commercial? No. They are all zoned DE1, except one of them is zoned DET3. Those are all desert estate residential designations. What prevents the city from just changing the zoning? They could, or they could change their own ordinances. I think that's potentially more litigation, but I think that's one of the reasons why I think judicial reference with the Los Palos owners and a judge deciding what they can do is better than just hammering on the city in their own meetings, because they can just change their own ordinances. Any grandfathering of the property usage? No. These are restrictive covenants binding on the current owners of the land. That's why we have to name all of the Los Palos homeowners. Let's see. Have I covered? Can I ask Miles and the city why they're not they are a commercial enterprise? They've admitted it to me. Miles's attorneys agreed, I believe it's in one of the letters, that these are commercial uses. So that's going to be, that's the center of the case we're going to have with them. So let's see. I don't see any more hands raised, and the questions in the chat slowing down. Anybody else? I think we'll probably have these town halls at various junctures. If you have, other observations or reports, please communicate through management. Sorry, Rick, you're going to get a bunch more emails. Please communicate through management rather than directly with me, just so there's some sort of, contact point. I don't like to ignore, all the homeowners, but there's a lot of you, and I don't want to run up a bill, responding to all of your emails. I report to the board while the association is the client. But I think we'll probably have these town halls at various junctures. There's one more question. I'm guessing you don't want to reveal owners and renters and lessors. The owners are public record. The owners as of 2016 are listed on the easement agreement. The temporary party renters, I don't always have that information. It's not secret, and if I get it, I'm happy to share it. This is all going to be public information in the judicial reference case. So I'm not keeping it confidential. We don't always get that information. Without our HOA TUP approvals, can they hold events? They can hold, well, that's a complicated question. The city is, I think, very reluctant to issue TUPs without our approval. And so there are some types of events that don't require a TUP, like when Mr. Warner had his wife's 40th birthday party there last month. That doesn't require a TUP, just like if you were having, a birthday party or a, gathering at your house. But if you're renting your house out for a big event with, over a certain number of people, it triggers the requirement of a TUP. And I don't think the city's going to issue them over our objection. They were very, very careful and skittish around all this all summer and fall. There's a lot of correspondence around this. So let's see. One more question, but it could violate the easement. Yeah, certainly. That's the whole point. I think a lot of the stuff violates the easement. Again, a small family gathering may not violate the easement, but renting out the party houses for big parties certainly does. So anyway, I think hopefully we've got everybody's questions answered. Again, if anybody has anything I haven't gotten to, I don't mean to ignore anybody. Go ahead and raise hands. I closed the chat just so I can't look at it again, but raise hands if you want to. Is there guidance on how far in advance the TUP is supposed to be issued? Yeah, 30 days. That's in the city ordinances. Again, their ordinances are on the city website. Easy to look up. So get the town halls for free. The Zoom is free. So anyway, thanks for your time, everyone. This was recorded. I believe this is going to be made available to people. If you guys want to go to the next city council meeting and raise this with the city council, again, I'm not directing that. I don't think it's a bad idea. And I'm not hinting not to. I'm just saying that's not what we're doing. We're handling the legal proceedings, the judicial reference, and any litigation we have. So, yeah, go to the city council meetings and talk to the planning commission. This is a big issue facing the whole city. It's not just you guys in Los Palos. This is across all of India. That area is growing so quickly. Like I said earlier, I think the city's kind of back on their heels trying to deal with all this stuff happening more quickly than they've been able to catch up. So anyway, yeah, I feel like I've updated you guys about where we are so far. I've got, my partner Teresa, Felicia, and I have more specific strategy. Again, we like to hold some of our cards in our pocket, and I don't lay out all the details of what all my tricks are with an audience of 125 people. But we've got a plan going forward. I think we've shared the overview with you guys. And like I said, we'll have these at various junctures. And thanks for your patience and for being vocal. We will hopefully get this under control. That Los Palos probably should not have been built in the middle of your community like this. They should have given them a road. But it is what it is, and the idea is to get it under control from here going forward. Okay. All right. Thanks, everybody. I think we've covered everything. All right. Any last burning questions? Okay. Thanks for joining, everybody. Let's say we'll have additional meetings in the future. Okay.